The following presentation contains legal commentary and analysis of the law on freedom of religion or beliefs and legal status of religious communities enacted by the Republic of Montenegro on December 27, 2019. Since the controversial law's enactment, concerned citizens in Montenegro and across the world continue to organize massive protests due to the law's infringement on the inalienable rights to religious freedom and property. The Montenegrin government's refusal to repeal this law is of particular concern to Americans because Montenegro is a member of NATO whose membership is fully supported and funded by the United States of America. According to the national jurist, Ilijana Todorović is one of the top 15 foreign attorneys in the United States and a holder of 3 Masters of Law degrees with highest recognitions. She is licensed to practice law in Louisiana, New York, and Washington, D.C. The reproduction and distribution of this presentation without written permission by the creator is prohibited.
Hello everyone, my name is Ilijana Todorović and I'm an attorney in the United States. I wanted to do this video presentation and talk about the Montenegro law, which has caused a lot of tensions and concerns. It's the law on freedom of religion or beliefs and legal status of religious communities. That's the official title. As someone who is a holder of 3 Masters of Law in American Common Law, International Legal Studies, and Civil Law, and who is an attorney in both the common law and civil law jurisdiction, I thought that my background of having this kind of unique blend of proficiency in different legal systems would help me explain this legislation to laypersons, just ordinary people who do not have any legal training, but who are at least indirectly impacted by this law. So that'll be my goal here today, really, to try to explain this law by using the text of the law itself in an objective way and by using relatable examples that everyone can understand. I don't want to impose any conclusions on you. There are no political connotations here. My goal is just to present the legal issues to you, and then you're free to make whatever conclusions you find most appropriate and which make most sense to you. Before we dive into the substance of the law, the articles of the law, I wanted to address one thing first. The criticism with respect to this law is that of discrimination and violation of the right of freedom of religion. So before we start analyzing the text of the law itself, I would like to make one point first. Generally speaking, there are 3 types of law. The first type of law is the law that is discriminatory on its face. So when you look at the text of the law, you see that it's discriminatory. For example, women cannot vote. This law, which used to be in effect in not so distant history, discriminates on the basis of gender. It's clear, women are not allowed to vote. And let me mention here as a side note that just because a law exists or was enacted, it doesn't necessarily mean that it's illegal. There are many laws that are illegal or that were proved to be illegal and they got repealed after the fact. And this was one of them. So bear that in mind, but that's the first type, a law that is discriminatory on its face. The second type of law is law that it's neutral on its face. When you read the law, it treats everyone the same. But the law has a discriminatory motive or intent. It's discriminatory in its application or it has a discriminatory impact. So when you read the law, it looks just fine. It applies to everyone equally. But when you look behind the law, there's some consequences there that may be an issue. For example, and this is a very hypothetical example, I'm just trying to illustrate the point. Let's say that we have a bank. Let's say that a law was passed that says the money of all people who have an account at this bank now belongs to the bank itself. So the money is no longer yours. That's what the law says. Again, very hypothetical, but bear with me here. When you look at the law, it is facially neutral, but its very terms, it applies to all people, to everyone who has an account at the bank, right? So no issue there. But let's say that we have a person A, and let's call that person Alex. And Alex is the kind of person who does have an account at the bank, but he doesn't trust banks very much, and he only has $100 in his account. And let's say that we have a person B, Bobby, who put all of his life savings, $100,000 in his account. The law is the same for both Alex and Bobby, but it impacts them differently, right? While Alex stands to lose only $100, Bobby will lose $100,000 to the bank. Now, Alex will but it will ultimately say, whatever. They're only going to take $100 from me. It's not worth the headache and time fighting it. It is what it is. But Bobby's reaction, as you can imagine, would be much more unforgiving. So you can see how a law can be facially neutral, but have a disparate impact on different people, depending on what the facts are and what's at stake. Well, what's important to highlight here is that both the first type of law, the law that's discriminatory on its face, and the second type of law that we just talked about, the law that's facially neutral but has the discriminatory impact or motive, are equally against the law, okay? And then we have the third type of law, the good type of law, which is the law that does not discriminate on its face and that does not have a discriminatory impact, and it's not applied in a discriminatory way. So why did I want to go through all of this introduction? Because I wanted to be clear from the get-go that the Montenegro law on religion that we're talking about here belongs in the second category. It's a neutral law. It applies to all religious communities, the Jewish, the Islamic, the Catholic, as well as the Christian Orthodox community. But then you may ask, as well as many people do, why is it that the Serbian Orthodox Church is the loudest in its protest against the law? Or why is it the only one protesting? Well, because the law has the largest discrimination against it. It discriminates against everyone, but mostly against it. The Serbian Orthodox Church is Bobby from our previous example, right? How? Well, I'm not going to dig into the motive behind the law, but let's look at the consequence. According to the information that I was able to find, and please do correct me if I'm wrong, almost 70 to 75% of Montenegrins identify themselves as Orthodox Christians. And that's not surprising considering that the Serbian Orthodox Church was historically intertwined with Montenegro statehood at the time when Montenegro was a theocratic state. By analogy, the Serbian Orthodox Church has and stands to potentially lose to the state incomparably more land, churches, monasteries, and other property than all of the other religious communities combined. So other religious communities, who are Alex from my previous example, right, may not be as eager to fight the law as the Serbian Orthodox Church because they don't stand to lose nearly as much. So instead, they may be more inclined to strike a deal with the government, which the law allows them to do, without actually investing the time and effort to repeal the law, although the law affects them and their believers as well. And we'll see later how. Okay, now with that out of the way, what is actually an issue with this law? Is there even an issue? What, if anything, is the problem? Before we dive into that, I would like to share one more quick note. When this law was brought to my attention and when I saw the protest and the dissatisfaction among the people, I said to myself, well, wait a minute, what's going on here? So I went to the source itself, the website of the government of Montenegro, and downloaded the text of the law because I wanted to read it myself in its official version. And it's not a very lengthy law by any means, so I encourage everyone to look at it. So as I was reading it from a purely scholarly perspective, and as a lawyer whose job is to argue or defend the law, I noticed a lot of issues. And as I'm talking here, I will have on the screen some of my notes and scribbles that I was jotting down in the text as I was reading it. Of course, you won't be able to discern any of it, but there was almost not a single article out of 66 of them that did not have some kind of a deficiency. Grammar mistakes, poor translation, bad structure, contradictions with other laws of Montenegro, unconstitutional provisions, and many other things that a good law must not and cannot have. And I will show you exactly what I mean. You'll be able to see the laws and the articles for yourself, and you'll get to determine whether or not they contradict each other. That will be entirely up to you. But we can finally start with the law. And we will work kind of backwards because the most controversial articles are located at the very end, which, by the way, is only one of several violations of the legal and technical rules for legal drafting, which were established pursuant to Article 31, Paragraph 2 of the Rules of Procedure of the Government of Montenegro. But we will leave that to the side because this would otherwise be a 5-hour video. So let's start with Article 62. I will not be wasting my time on reading the text out loud. I'll keep it on the screen so that you can read it yourself. There are so many things to cover here, but I guess we can start with the basics and then work our way down. In simple terms, Article 2 essentially says that certain religious buildings and lands, and we'll later see which one those are, but certain ones used by religious communities in Montenegro are cultural heritage of Montenegro. In other words, they're now owned by the state. First of all, it's worth noting that this law deals with the freedom of religion and status of religious communities. I am not really sure how cultural heritage and state ownership of religious properties came into the picture here, especially because Montenegro already has the law on protecting cultural heritage as well as the law on state property. But I'm sure that there are much more intelligent people in the Montenegrin government who can explain that for those who may be interested. As we will see later, the law on freedom of religion directly contradicts both of these laws. But anyway, again, certain churches, cathedrals, mosques, synagogues, monasteries, and so on now belong to the state. But no need to panic, because the state officials are saying we are going to allow people to continue to use these properties. So nothing would really change. Don't worry, guys. We're not going to kick you out or take these properties away from you. It's just that the name of the actual owner will now be the state and not the religious communities themselves. That's all. Okay, well, let's pause here. There are two scenarios. Either the state officials are telling the truth or they're not telling the truth. And let's start with the first scenario. The state officials are not telling the truth. If that's true, then that would really be a huge problem, right? Because not only would the state be deceiving its people, which is what no state should be doing, but the state would also ultimately be engaging in an unconstitutional act, which is illegal expropriation of private property. And Article 58 of the Union Constitution, as well as Article 1 of the Protocol to the Convention of Human Rights and Fundamental Freedom, state that no one, religious communities included, no one shall be deprived or restricted in his property right. But that's the first scenario. But why should we even assume that state officials would be not telling the truth, right? We shouldn't assume that. So let's move on to the second scenario, which is that the state officials are telling the truth and that although the state would now be the owner of the religious lands and buildings, the state would allow the religious communities to continue to use them. There's nothing wrong there, right? The state is doing the right thing here. Oh, well, not really. Actually, if the state officials are in fact telling the truth, that's even a bigger problem than if they were not telling the truth. First, let's look at the Article 64 of the Law on Freedom of Religion, which says that the religious communities may continue to use these properties until the decision of the competent state body, and it doesn't say which body that is, but a certain body, is made on easement, right use, and disposal of these properties. Translation, you get to use these properties until we say you can't use them anymore, right? Which is kind of laughable. Second, if what state officials are saying is true, then the state action of allowing state property to be used by religious communities would be illegal. How? Well, Montenegro already has the law on state property, and Article 8 of that law specifically says that state property shall be used for performing the functions of Montenegro, local self-government, state authorities, and so on. And you know what else Montenegro has? A constitution. And Article 14 of the Constitution says that religious communities shall be separated from the state. This is what we call the principle of secularism, or separation of church and state. So if the state officials are saying that they're going to allow religious communities to use state property, which is what Article 64 in essence says, that would violate both Article 14 of the Montenegrin Constitution as well as Article 8 of the law on state property, which says that the state property must be used for governmental or public functions, meaning the consequence of this law on freedom of religion is an unconstitutional desecularization of Montenegro. So even in its most simple and generalized terms, the law seems to be problematic, to say the least. But let's dig deeper. Remember how we said that this law applies only to certain land and buildings? Well, Article 63 says that there are three categories of religious property to which this law applies. We'll break them down and discuss them in turn. And there's really a lot to cover here, so bear with me. The first category are religious buildings, which, by the way, is a term that is not defined anywhere in the law, so we're not really sure what is considered to be a religious building, but religious buildings and lands that are being used by religious communities in Montenegro, which were built or obtained from public revenues, are cultural heritage and now belong to the state. First of all, in my opinion, the word exclusively must be added here. They had to have been built exclusively with public revenues in order to stand a chance to be considered state property. Because if any private donations were used, as they usually are when religious structures are erected, then we have to talk about who contributed how much. But this article doesn't account for that possibility. But anyway, built or obtained from public revenues. So if a church or a mosque or a cathedral were built, again, I would add exclusively with state's money, it should belong to the state. Okay, makes perfect sense, but who's supposed to prove this? Some of these religious buildings, how they're called, were built centuries ago. So who, under the law, bear the burden of proving that they were built with public money? And for those who are not attorneys or legal professionals, let me just say that burden of proof is a big deal. It's a huge deal because it sets who and by what evidence must prove something. It sets a bar. And I'll give you a very good example. In civil cases in America, the burden of proof is that by the preponderance of the evidence, which means that a plaintiff, the party suing, must prove his case by only 51 or more percent. In criminal cases, on the other hand, the burden is that of beyond a reasonable doubt. So the prosecution, the state, must show that there is no reasonable doubt that the defendant committed the crime for which he's charged. Whether or not you can reach that bar in civil cases is here, in criminal cases is right here, determines whether or not you will win the case. The issue with this law is that it makes absolutely no mention of who bears the burden of proof, although the Venice Commission specifically flagged this as a problem and said that that must be specified. But it's not. Let me add, under the laws of pretty much every state in the world, possession of property is indicia of ownership. So a possessor of a thing is considered to be a provisional owner of the thing that he possesses until someone else's ownership is established. So there's a presumption of ownership accorded by the law in favor of the person or entity that exercises factual authority over a thing. To explain it a bit better, here's an example. If I'm exercising control over this pen and using it to write with it, it's presumed that I'm the owner of the pen. If my coworker were to come in and claim that it's her pen, she would have to prove it, right? Either prove that she only borrowed it to me to use it today, or that I stole it from her. Until she proves that, I get to keep the pen because I'm presumed to be the owner. So the burden of proof of ownership rests with the party seeking to establish it. My coworker in the pen example, and with respect to this law, the state of Montenegro, because it's the state that's seeking to establish that these religious buildings and lands are in its ownership. But the law as written does not say that, although that part is very important. So one may ask why? Why wouldn't such a serious law as this one that deals with fundamental human rights include such serious provision on burden of proof? We could only guess. And I said in the beginning that I won't be opposing any conclusions on you, but I will mention that the only way that the state would be able to meet this burden of proof would be if the state had in its archives documents dating back centuries that would show that these churches, mosques, and cathedrals were built with public money. Could the state meet this burden? Well, how possible is it that the state would have copies of receipts and contracts and documents from, let's say, 900 years ago, which is how old the oldest church in Montenegro is? Okay, moving on. That's the first category. If the religious buildings were built with public money, they're cultural heritage and belong to the state. The second category, under Article 62, are religious buildings and lands that were owned by Montenegro up until December 1st, 1918, and for which there's no evidence that they're owned by the religious community. These are also now cultural heritage and belong to the state. We already talked about the evidence, so the state must show that the state owned the property before December 1st, 1918. As an example, the state cannot accuse me of a crime and require me to prove that I did not do it. That's nonsensical. The state must show that I did the crime for which I stand accused, okay? So why December 1st, 1918? Because that is the date when Kingdom of Serbs, Croats, and Slovenes was established and Montenegro ceased to be an independent country. So the law says any religious property that belonged to the independent country of Montenegro prior to December 1st, 1918 are now cultural heritage of Montenegro. Okay, makes sense, arguably. I don't have time in this video to talk about the issue of state succession, continuation of legal personality, and the Vienna Conventions. We'll leave that for another time. But to a layperson, it makes sense. Is there an issue? Well, let's see. The law says before 1918. So we have the end point. What is the beginning point? How long back from 1918 do we go? This is important because it is this time frame that determines the state that allegedly owned these properties. Montenegro, as it exists today, was home to many mini-states through its history, such as independent Duklja state, Rosetta state. It was a part of the Serbian medieval state. It was also under the occupation of the Ottoman Empire, at which time it had autonomy as a theocratic state headed by the prince bishops. I mean, I'm not a history expert by any means, nor do I want to teach anyone about their history. Montenegrins know their history better than anybody else. But the point is that it was not until 1878 that Montenegro's independence was recognized at the Berlin Congress. So we are talking about a period of only 40 years that Montenegro was formally an independent country prior to 1918 because the country's legal continuity was interrupted by the existence of these other states. So the law could only refer to the window of time from 1878 until 1918 and cannot apply as written to just any property owned by, quote unquote, Montenegro at any point before 1918. So when Article 62 says owned by the state prior to 1918, the question has to be asked by which state and when exactly prior to 1918. So Article 62 is, to say the least, incomplete. But that's the second category. The third category of properties that stand to be confiscated by the state under Article 62 are religious buildings that were built in Montenegro up until December 1st, 1918, with joint investment of the citizens, and for which there is no evidence of ownership, are now cultural heritage and also belong to the state. First of all, the law says joint investment of citizens, but notice that it does not specify citizens of which country or state, which again relates back to what we just discussed about how many possible states existed within Montenegro's borders prior to 1918. Second, again, it does not state what kind of evidence would be sufficient to prove ownership, and we already talked about that as well, so I'm not going to repeat myself. But even disregarding these two issues, it is unclear what exactly does joint investment mean. When a religious community is building a church or a cathedral or a mosque, contributions come from all over the world and from citizens of many different countries who are of that faith or whose ancestors are from that area. I'm not sure how credible this information is, but I also read somewhere that even the Romanov family members of the Russian imperial dynasty, contributed large sums for erection of some of the Orthodox churches in Montenegro. So in order for these religious buildings to be state property, the citizens of independent Montenegro, which would be between 1878 and 1918, would have to have contributed all of the funds for their construction. But what if their contributions were only 15 or 20 or 25%, while the citizens of other countries paid the rest? Could it still be state property? Would it be just and fair for it to be state property? Even more importantly, we discuss how the burden to prove all of this would rest with the Montenegrin state because the state is the one seeking to establish ownership. How will the state prove that the contributions were made by its citizens within this 40-year window of time and in what amounts? What documents could they possibly have to show? I'm not sure. But let's look at this too. The period that we're talking about here is from 1878, when Montenegro was recognized as an independent country, until 1918, when it ceased to be independent. So it encompasses the year of 1905. Now, back in 1905, Montenegro had another constitution, Constitution of 1905, that's how it was called. Article 140 of that constitution specifically stated that institutions of charity and of works having an ecclesiastic or scientific object funded by individuals must be approved by the authorities. And, watch this, their property and their endowments cannot, according to that constitution, cannot be considered as property of the state. If these religious buildings stand to this day, and they do, that means that they were, at some point in time, approved by Montenegrin authorities as it was required by the constitution, because otherwise they could not have been built or registered in the cadastre, right? But now, in 2019, the state is coming in and, contrary to the constitution, is passing a law that applies to the period before 1918, and that makes it all state property. So the state is retroactively, unconstitutionally expropriating this property. Retroactive application of the law is, as you know, not legal. In fact, given its retroactive application, this law is in practice considered to be a lex specialis, but it was not passed following a special procedure and after meeting certain requirements that such an ex post facto law demands. Instead, the law violates Article 147 of both the old 1905 Constitution and the current Constitution of Montenegro that is now in force. It's the same number article in both constitutions, and both include this prohibition of retroactive effect by providing that a law and other regulations shall have no retroactive effect. So, is there a problem here? Yeah, it seems like there is. So that's in a nutshell Article 62, and there are many more things that we could have addressed here, but for the sake of preserving time, we will stop here and move on to Article 63, which is equally as important because it shows you the procedure or lack of procedure behind all of this. So let's look at a text of Article 63. First, it states that the public administration authority, without specifying which one, shall identify buildings and land owned by the state. The key word here is identify. Whichever authority that ends up being, and we don't know which one it is because the law doesn't say, it cannot merely identify any properties. It will have to prove that these properties are owned by the state by producing evidence to that effect. This again relates to the burden of proof element that we talked about earlier. Second, once the religious buildings and land are so identified, Article 63 says that this unnamed authority must make an inventory of such properties and submit a request to register the state as the owner of those properties in the real estate cadastre. The way this article is written implies that there will be only one request for all of the properties listed in the inventory, which is practically impossible and legally not allowed. But anyway, this request is then registered in the real estate cadastre within 15 days from the submission, thereby concluding the registration of state ownership. And oh yeah, they will inform you, the user, without delay that the property now belongs to the state. So that's pretty much the procedure. But before we dive into the analysis of that procedure, let's translate this article into practical terms by using an easy example. How will this work in real life, right? Well, let's say you own a house, and this law hypothetically pertains to ownership of houses as opposed to religious buildings. The law essentially says this: someone who works for the state, we don't know who it would be, but the state will send someone out to browse the area, to look around and see what properties could they now say that are owned by the state. So let's say that person, that state official or employee, points a finger at your house and he identifies your house as belonging to the state. Maybe your house was built with help of the neighbors or family members, which will fall under the joint investment of citizen category. Or maybe the state gave you some money or subsidies for the cement or construction materials, which would fall under the use of public revenue for construction. Or maybe your ancestors built the house prior to December 1st, 1918. So if this person that the state sent thinks that one of these elements are met and says that your house should be owned by the state, this person will put your house on the list together with other houses and write a request to another state body to say, here they are, here's the inventory. We request that all of these houses listed here, including yours, now be registered in state ownership. 15 days after this request is submitted to the real estate cadastre, the state becomes the registered owner of your house. There is no evidence that the state ever owned your house, that other people helped you build it, or that the state gave you some money to build it. No evidence, no hearing. You didn't get a chance to appear before a judge to present your side of the story or to hire an attorney to defend you. And guess what? You have no right to an appeal, which we'll talk about in a minute. But that's pretty much the end of the road. Your house is gone. Think about that for a second. If this law was to apply to people's houses and homes as opposed to religious buildings, would you protest against your house being taken from you in this way? Give that a little thought. But anyway, let's take a look at some of the issues. We talked about the request to be submitted to the cadastre. The law does not specify the legal significance of this request. This is important because without such specification, what is this request? What way does it have? It is nothing more than a self-serving document generated by the state to allow the state to unilaterally and without proof seize the property in favor of the state. Very convenient, you'll admit. But more importantly, Montenegro has this law that I have on the screen, like any other normal country, called the Law on State Surveying and Cadastre of Immovable Property. And I'll just call it the cadastral law to make it easier. It's a mouthful. Article 63 of Law on Freedom of Religion is in clear violation of this cadastral law. How? Well, let's see. Article 86 of the cadastral law expressly states that the registration of property shall be done based on the documents that are valid in form and that do not have any deficiencies or suspicion as to their credibility. So if you're looking to register, change, limit, or terminate a right on some immovable property, you can only do it with a document that must contain clear and equivocal legal ground for such registration, change, and so on. This request that's mentioned in Article 63 of the Law on Freedom of Religion clearly does not meet any of these mandatory requirements because nowhere does Article 63 say that that request must have a legal ground, a clear and unequivocal legal ground as a matter of fact. But we saw that that request is based only on observations and thoughts of a state employee who was browsing the area and thought that state may have a claim to your house. Further, Article 9 of the cadastral law says, look, it's not an issue. You actually can use a public document, which this request would arguably be because it would be generated by some, we don't know which public administration authority, but you can use a public document for registration of ownership in the cadastre. But Article 89 then goes on to say such public document must fall in one of these four categories. It must either be a document on legal transactions, like a contract or something like, a decision of a court or settlement among the parties, other final and non-appealable decision of a court or another competent authority, or foreign document, which is considered to be a public document under the law of the country where it was generated. As you can see, the request under Article 63 of the Law on Freedom of Religion is not on that list. And it clearly does not fit into any of these four categories. It's not a court decision, not a settlement, not a foreign document, and so on. So Article 63 of the Law on Freedom of Religion is in violation of both Articles 89 and 86 of the Montenegro Law on State Surveying and Cadastral Removal Property. And moving on very briefly, I'd like to touch upon this as well because it's very important. Article 63 of the Law on Freedom of Religion is also in violation of the Montenegro Constitution, Article 20, which provides that every person shall have the right to a legal remedy against a decision on his rights or legally based interests. So every person has a right to an appeal, but the law on freedom of religion is silent as to any procedure for an appeal or a grievance, thereby precluding the religious communities from procedurally participating in this process, which, by the way, violates their constitutionally protected rights. Speaking of which, not only does the law on freedom of religion have to provide for a legal remedy, but that legal remedy must be suspensive. In other words, it must freeze the status quo. So you get to continue to use and own your house, from the previous example, until the state comes up with tangible or clear and equivocal evidence to prove that it owns it, and until it wins a final non-appealable judgment against you. That, of course, can take years and even decades, which is exactly why the process has to be suspensive, because you can go bankrupt or die fighting this in court without having lived in your house in the interim. But let me tell you this too. The Montenegrin officials expressed to the Venice Commission that a suspensive appeal would be included in this law. As we saw, it's not in there. It's not anywhere in there. But here's the most interesting part. Even if the law on freedom of religion did include an article on suspensive legal remedy, that would be in violation of the Montenegrin cadastral law that I mentioned a moment ago. Article 125, paragraph 2 of that article actually specifies specifically that the appeal shall not postpone execution of the decision in 3 situations, and it lists both registrations made by operation of law and post-registrations in cadastral removal property, which is what we're talking about here. So Article 125 of the cadastral law says that the appeal cannot be suspensive, even though the Montenegrin government officials were convincing the Venice Commission that it would be. Okay. Let's say that these government officials just made a minor slip up. It happens to the best of us, right? We know that the Constitution says that everyone must have a right or has a right to a legal remedy. There's a constitutional right to an appeal after an unfavorable decision. There's no question about that. But maybe they meant to say that it would be a devolutive as opposed to a suspensive legal remedy. Okay, well, if the law were to provide for a devolutive as opposed to a suspensive legal remedy, that would be in violation of the Montenegrin Constitution, Article 46, and the European Convention of Human Rights, Article 9, as it would infringe both on the religious communities and individuals' rights to manifest their religion or belief in worship, teaching, practice, and observance by depriving them of places and opportunities to do so. So, you see, the law on freedom of religion is written so poorly that no matter which option or scenario you consider, it would violate another law of Montenegro or the Constitution itself. And that's problematic. Now, I can talk about many other things with respect to this law, but I think that this would be sufficient. And I have to mention, for example, one of the other things is that the fact that the law fails to differentiate between the existing versus new religious communities and fails to provide clear instructions for their registration procedure. So one of the primary purposes of the law, which is, as the title of the law says, the legal status of the religious communities, is not achieved. And I mentioned in the beginning that there's almost not a single article that is free of error. But I think that this would be sufficient to at least give you some picture about this law. And there are issues, no matter what side you're on, and everybody should be on the same side here, which is the side of the freedom of religion for everyone as a fundamental human right. These inconsistencies cannot be ignored. They're staring you right in the face. When you are enacting any kind of law, there are things that you need to consider, account for, and put in place. You also have to know other laws that already exist in your country so that you don't enact a law with those already existing laws. I really have no way of knowing if everything that we just talked about here was taken into consideration when this law was passed. If those people who raised their hand in the National Assembly and voted in favor of this law knew of all these other laws that this particular law is violating. If they didn't know, then that in and of itself is a major problem. If they didn't know, how is it then possible that they voted for it? That's a problem too. Maybe they had the right idea, they wanted to do the right thing, but that idea just didn't translate into the law. And we could only go by what's written in the law. We can't go by what state officials are saying on TV or in their interviews. Their explanations are irrelevant. My explanation is irrelevant. The law speaks for itself. I can't stand in court before a judge and tell the judge, Your Honor, don't mind what the law says, scratch that. This person or that person said on TV yesterday that that actually means this. Any judge will laugh at me and tell me, thank you, but I can read the law myself and see what it says, right? I just hope that this video helped clarify some parts of the law and from a legal and practical perspective, helped you see some of the concerns of those people who are protesting against it. If you really try to understand this law, which I sure as heck did try, there's no way you could overlook these glaring contradictions. But again, as I said in the beginning, that conclusion is yours and only yours to make. Thank you all for watching. Veliki pozdrav I svako dobro.